You know how sometimes you feel like you're just wading through endless terms and conditions just to use some basic service?
Oh, absolutely.
Well, today we're going to try and cut through some of that, focusing on one really important bit: arbitration in consumer disputes.
Hmm.
Might sound dry, but stick with us.
That's right, because think about it. The last time you signed up for, I don't know, a credit card, a new phone plan, even just clicked agree on an app update.
Yeah.
Chances are the word arbitration was buried somewhere in all that text.
And that's the thing, isn't it? So many of us, and I definitely include myself here, we click agree or sign without really getting what it means.
Exactly.
But as we're going to explore in this deep dive, that little click, that signature, it can actually have some pretty big consequences if you end up having a problem with that company later on.
Precisely. So our mission today really is to unpack arbitration. We want to break down what it actually is, how it works in the real world, and what it means for your rights when you're dealing with companies.
And we'll hit the pros and cons too, right? What to look out for.
Absolutely. The good, the bad, and the things you really need to be aware of.
Okay, let's dive in then. What is arbitration? Like in simple terms.
Okay, so at its heart, arbitration is basically a private alternative to going to court.
Mm.
So instead of having a judge, maybe a jury, decide your legal disagreement, you have a neutral third party, they're called an arbitrator, listen to both sides, and then they make the decision.
And you said private. So is it kind of like, I don't know, Judge Judy, but without the TV cameras, maybe in a conference room? Is that a fair way to think about it?
That's actually a pretty good analogy, yeah.
Yeah.
It gets the idea across. It's meant to be a resolution process outside the public court system.
Okay. And I heard the key word in there was that the arbitrator makes the decision.
Yes. And crucially, that decision is usually binding.
Binding. Okay, that sounds important. What does binding really mean in this context?
It means that, generally speaking, the arbitrator's decision is final. You have to abide by it, and there are very limited options to challenge it in court later.
Okay. Now, proponents often say it's faster, maybe cheaper than court.
That's the argument, yes. It can be quicker, sometimes resolving in months instead of the years a court case might take, and potentially less expensive. Fewer formal procedures, maybe lower upfront costs compared to court filings, and extensive legal work.
Okay, faster, maybe cheaper. Sounds potentially good. But I sense there's a but coming. What's the trade-off?
There's a really significant trade-off. When you agree to arbitration, usually in that fine print we mentioned,
Right.
you're almost always giving up your right to sue that company in a regular court.
Wait, say that again? Giving up your right to sue.
Yes. And often alongside that, you're also giving up your right to participate in a class action lawsuit.
Wow. Okay, no suing in court and no joining forces with other people who might have the exact same problem. That is like a massive thing to agree to, especially without maybe even realizing it.
It is massive, especially if the stakes are high or if it's an issue affecting lots and lots of consumers in the same way. Think about data breaches or faulty products.
Yeah, exactly. So that waiver, that giving up of rights, is really the core of why this matters so much.
Absolutely. And that brings us right to the next point. Where do we actually encounter these clauses?
Yeah.
Because like you said, it's not like we actively remember signing an arbitration agreement.
Right. I can't recall ever seeing a big button that says, click here to give up your right to sue.
No, they don't quite phrase it like that. It's usually tucked away in those long, dense terms and conditions documents.
The ones nobody reads.
Pretty much.
Yeah.
Think about your credit card agreement, your cell phone contract. When you buy things online and click I agree to the terms, even some employment agreements or rental agreements, they're very common.
So basically, almost any standard consumer contract could have one.
It's incredibly common, yes. The wording might vary a little, but you're looking for phrases like resolve disputes through binding arbitration, or you agree to waive your right to a jury trial.
Binding arbitration. There's that word binding again.
Exactly. That signal of the finality of the arbitrator's decision we talked about.
So the reality is most of us just scroll past or click agree because we want the service or the product, and we're completely unaware we've signed up for this alternative dispute system.
That's the common scenario. You only tend to discover the limitation that you can't go to court when an actual problem pops up and you start looking into your options.
And then it's kind of too late. You're already locked in.
Often, yes. It can be a real shock to find out your legal avenues are much narrower than you assumed.
Okay, so we've established what it is, private judging, basically, and where it hides everywhere in the fine print. Let's get practical now. What are the actual pros and cons when you're in that situation? You mentioned speed and cost as potential upsides.
Right. So speed is a big one they tout. court dockets can be incredibly backed up, arbitration can often deliver a decision much faster, months typically, rather than potentially years.
Okay, speed is definitely appealing if you have a problem you want fixed. What else?
Cost. Now, this one is debatable, but potentially it can be cheaper. You might avoid court filing fees, maybe discovery is less extensive and costly, and sometimes, for smaller claims, people might represent themselves, though that's not always advisable.
Okay. Less formal, maybe less lawyer-heavy sometimes.
And you mentioned privacy earlier, too.
Yes. Privacy. Court proceedings and judgments are usually public records. Arbitration hearings and decisions are typically private, confidential. Some people and companies definitely prefer that.
Okay, so faster, maybe cheaper, definitely more private. Those sound like reasonable points. But I'm bracing for the downsides now. What are the big risks for the consumer?
Okay, the downsides are significant. Number one is the finality we keep mentioning. Your right to appeal an arbitrator's decision is extremely limited.
How limited? Very. Unlike court, where you can often appeal based on errors of law or fact, appealing an arbitration award is usually only possible under very narrow circumstances, like outright corruption or fraud by the arbitrator, or if they clearly exceeded their powers. Basically, even if the arbitrator just got the law wrong, you're often stuck with the decision.
Wow. So if you feel the arbitrator just didn't get it right or made a mistake, tough luck, essentially.
In many cases, yes. That lack of meaningful review is a major criticism.
Okay, what else? That's a big one.
Another concern is the potential for arbitrator bias, or at least the appearance of bias. Think about it. Large companies might use the same arbitration firms repeatedly.
Ah, the repeat player effect.
Exactly. A consumer is usually a one-time participant, but the company might provide that arbitration firm with a lot of business. There's a concern, whether perceived or real, that arbitrators might consciously or subconsciously favor the company that hires them regularly.
That makes sense. It could create an uneven playing field from the start. Feels inherently unfair if the judge might be subtly biased towards the other side.
It's a significant concern for consumer advocates, definitely. And then we come back to the loss of class action rights.
Right. Why is that specific point so critical?
Because class actions are often the only practical way for consumers to hold companies accountable for widespread harm, where each individual's financial loss might be relatively small.
Like a $15 illegal fee charged to millions of customers.
Precisely. No single person is likely to spend the time and money to arbitrate over $15. It's just not worth it individually. But bundled together in a class action, it becomes a major case that can force the company to change its practices and compensate everyone. Arbitration clauses often explicitly ban class actions.
So, by forcing individual arbitration, companies can effectively make it too costly or too much hassle for individuals with smaller claims to pursue them at all.
That's a major impact, yes. It can shield companies from accountability for practices that harm many people in small ways.
Okay, well, it paints a pretty complex picture. It feels a bit like consumers are often put in a tough spot with these clauses. So, the big question, what can we actually do about it? Can we avoid agreeing to arbitration?
Sometimes, but it's rare and requires vigilance. A few companies include an opt-out provision.
An opt-out? How does that work?
It usually means you have a very short window, maybe 30 days, sometimes 60 after you agree to the main contract, to send the company a physical letter, or maybe an email specifically stating you reject the arbitration clause.
A physical letter. In this day and age?
Often, yes. They don't always make it easy. You have to find the clause, understand the opt-out procedure, and act very quickly.
Let's be realistic. How many people actually do that? You'd have to read the fine print immediately and then take that extra step.
The numbers are incredibly low. Most people don't even know the option exists, or they find out too late. But it's worth checking for, especially in really important contracts, employment, major purchases, financial services. It's your best, albeit slim, chance to preserve your right to go to court.
So step one is actually trying to read the key parts of agreements, looking for arbitration and opt-out. Tedious, but maybe necessary sometimes.
It's good practice, even if you don't opt out, just to know what you're agreeing to.
Okay, but let's say you didn't opt out or couldn't, and now you have a dispute and you're heading towards arbitration. What then? Are you just stuck?
Not necessarily stuck, but you're playing in their ballpark, so to speak. The key is to understand the rules of that specific arbitration process. Gather all your evidence, emails, receipts, contracts, photos, whatever supports your claim.
Be prepared.
Absolutely. Be clear about what happened and what resolution you want. Present your case strongly and clearly to the arbitrator. Just because it's not court doesn't mean you shouldn't advocate for yourself effectively.
Right, don't just roll over.
Definitely not. And crucially, if you feel the process seems unfair, if the stakes are high, or if you're just feeling overwhelmed by the legal aspects,
Yeah.
seriously, consider talking to a lawyer who specializes in consumer rights. They can explain your options within the arbitration framework, help you prepare your case, and make sure your rights are protected as much as possible during the process.
That seems like really solid advice. Having an expert guide you through that less familiar territory could make a huge difference.
It really can. Knowing the rules of the game, even if it's a game you didn't necessarily choose to play, is vital.
Okay, so wrapping this up. It sounds like arbitration isn't inherently evil. It can sometimes be a faster way to resolve things.
It can be, in theory, and sometimes in practice.
But the big takeaway for us as consumers is really about awareness, isn't it? Knowing that these clauses exist everywhere and understanding that clicking agree often means giving up really significant rights, like going to court or joining a class action.
That's the absolute key. Being informed is your best defense against getting caught off guard by the legal jargon hidden away. Don't let the fine print undermine your ability to seek justice if something goes wrong.
It definitely makes you think. It prompts a final question, maybe for everyone listening to mull over. Knowing how common these arbitration clauses are now, what's one realistic step you could actually take, starting today, to be just a bit more aware of them in your daily life?
That's a great question to leave folks with. What's that one small change you could make?
If this podcast helped you, don't forget to like, comment, and subscribe. Your support helps us keep making these videos. Thanks for watching.